Hello and welcome to A Question of Law. Now, this is City TV's legal education program. Now, on this show, we seek to break down the law as it pertains to our daily interactions in life and society. Now, the show is interactive. We do want to hear from you, so use the hashtag A Question of Law on all social media platforms. And the WhatsApp line is 0550-585832. We know some of you watch us from outside of the shores of Ghana, so kindly prefix that number with +233 when you're sending us a message. Now, my guests are seated. I'm going to introduce them to you. Don't go anywhere. My name is David Kwekusechi. We'll be right back. Welcome back. I have my guests seated. I have with me Selim Adonu, who is a private legal practitioner, as well as Clement Kojo-Akapam, who is also a private legal practitioner and a lecturer, senior lecturer of law at the Faculty of Law at GIMPA. Hello, gentlemen. Welcome.
Hi, David.
How are you doing?
Doing well.
Fantastic.
Good.
Yeah. Now, the conversations have been interesting in the last few days, talking about the abolition of the road tolls, I should say. And but the question we're asking right now is that the ministry seemed to have taken a decision based on something that was in the budget that was supposed to go to Parliament, for Parliament to deliberate and then pass into law. But the ministry seems to have jumped the gun. Did they actually jump the gun? Do they have, is it within their space and remit and jurisdiction to take decisions, to suspend certain tools and all of those things? Let's find out today on A Question of Law. Yes.
Was there a gun to even begin?
to even be jumped?
To even be jumped. I mean,
Well.
So, I think that this matter that has come up should enable us to clearly delineate the powers of the three arms of government, because it's very important.
Yes.
Because you're seeing a certain interaction between the executive and Parliament, which is occasioning what we are having by way of the facts. Minister goes to Parliament, reads a budget.
Yeah.
And that budget process, going to read it in Parliament, is a requirement of law.
Okay.
When to read it, where to present it, it's all a requirement of law. How to prepare the budget, is all so it's not just an exercise of the executive gets up and they think that, oh, we are going to read it. There's a process in law that you must follow.
Okay.
So an elected executive is giving the power to run the state. Now, in running the state, you must make budgetary allocations for different. So that's what we'll see the minister go to Parliament and do. Now, Parliament also has a duty of watching over the public purse. Okay. So then Parliament will debate the proposals and then
executive.
This is how Parliament communicates. Through the passage of an act, Parliament will now authorize the executive to go and spend.
Okay.
So that whole process is regulated heavily by law. Yeah. And you will see increasingly an interaction between the executive and Parliament to be able to have the state run. In other jurisdictions, we've had situations where they will say that we are going to a shutdown because we've not managed to reach certain deadlines. Okay. Yeah. And between the executive and Parliament, there's a certain tussle. And then if we don't meet the deadline, we go into a shutdown and it affects federal spending and things like that. We have a situation where we'll have to wait for Parliament to go through the process of passing what we'll call the Appropriations Act to now enable and authorize the executive to implement.
Is Parliament bound by law to execute this process within a particular time frame?
So the appropriation, because it's a bill.
Okay.
So it will go through the normal process. But because of its peculiar character, because it's a bill for spending, it's a bill of running the state, normally Parliament will speed up time in doing that. And you see that they will put up special processes to ensure that once it's read, there's a debate, they will go into the passage. So they will, with the necessary modifications on the rules for passing legislation in Parliament, they will take the proposals of the Minister of Finance through the process to pass the bill. But then, interestingly, we've had a situation where I have enjoyed the removal of the road toll. I mean,
Free flow.
The traffic has
it's not actually it's
diminished.
not an issue of traffic. It's just the fact that no, for us, where the toll booth that we use was not a question of traffic, but it's just whether or not even the tolls were being used for the right purpose and whether we can now aggregate more funds to use towards another. But that's another debate. What the minister did, was it within his powers? If you ask this question, I would say it depends.
Okay, interesting.
So it's not a clear yes or no answer. You understand? Because if you look at, we have a Road Toll Act or the Tolls Act. In the Tolls Act, it's the minister's responsibility to designate roads as tolled roads, to designate streets as streets where we'll collect tolls from. So that's his responsibility.
Interesting. Okay.
So the Tolls Act has given him that power. Now, to exercise that power, the law has also given him a procedure to follow.
Okay.
So the law says, if you want to designate a road as a road that will be tolled, do that by issuing a legislative instrument. Meaning you have to go to Parliament, 21 days, it will mature, and then that road will be designated. So yes, the minister has the power to designate areas or roads as roads that will be tolled, and that must be done through the issuance of a legislative instrument. So if it is not done through the procedure of a legislative instrument, then we'll start questioning whether or not the cessation of the collection is right or wrong. You understand?
Okay. I'm curious though, and I don't want to sound mischievous, but can he, within the powers of his office, not say, I'm suspending certain tolls for a period?
So that's what I'm saying. If we limit our discussion to the Tolls Act, the minister can suspend.
Okay.
But that suspension is not by the issuance of a letter.
Okay.
So the issuance of the letter.
That's where the problem
is.
Okay.
So that's, and even in relation to the collection of the tolls, if you look at so the minister can designate streets or roads that should be tolled, but when it comes to the fees to be charged, that responsibility is for the finance minister.
Wow.
So when it comes to the suspension of the collection of the fees, is the finance minister.
Okay.
When it comes to the suspension of that road being tolled, it is the roads minister. So you see, and all that must be done through the process for legislative instrument, because there is an acceptable way where the executive communicates, and how the legislature will communicate. So the executive will communicate when the act has given you authority as a minister over a certain area. The act will say the minister may, by regulation, do X, Y, Z.
But if I'm a lay person and I'm looking at all of this and looking at the way you've done the breakdown, then I can say quite easily that the minister jumped the gun, because we don't see an ally, do we?
We don't see an ally.
So without an ally,
no, jumping the gun is different from cocking the gun.
Hey.
No, Kweku, the minister can cock the gun for my analysis.
Okay.
But whether or not the minister can fire, you must follow a certain process. So what he did might be interpreted as cocking the gun. But that cocking the gun has led to the cessation of the collection, which shouldn't have happened. So that's so they will say that, we are being overly technical and that he can operationalize it. He has implied powers. Like, yes, you cannot claim implied powers when you
Yeah.
cannot point to an express power.
Yeah, that's
Because
true.
the law will give you an express power to do certain things.
Yeah.
And then when you are doing other things that are incidental to that express power, you can claim implied authority.
Okay.
So in this case, yes, you have the authority to designate roads as tolled roads,
Yeah.
but you don't have the authority to stop the collection of fees, because the fixing of the fees is also done by legislation,
Yes.
the
Yeah.
Fees Act.
Yes.
And under the Fees Act, the minister who is responsible
Is
is
the finance
the
minister.
finance
Finance
minister.
minister.
So I think that even if you look at all these, we might get to an interesting point where I will say that hence, when we are amending our Fees Act, for every specific fee, we should designate a responsible minister.
Okay.
So that when it comes to the fees on tolls, you say that the Minister of Roads may,
Yeah, do this.
by legislative
Yeah.
instrument, amend or
Yeah.
vary the schedule.
Because that seems to make,
Yes,
rational.
so
logic.
specific areas. So
Yeah.
if it has to do with agricultural implements, or then you make the minister of a grade.
Yeah, but very good point. But my thinking is the law is like that, giving the entire responsibility of fees and charges to the finance minister, because the finance minister must have a tap on charges and fees that will be slapped on people.
Right.
Fair
So, for example, if your suggestion were to be followed, then we will have a situation where every ministry or every minister, based on what he or she deems fit, will increase tolls or will increase fees and charges in various sectors.
Yes.
But the finance minister, per the current arrangement, will have to be meeting all these people so that at the end of the day, he or she has
Can
a
rationalize
bird's
all of
eye
it.
view
Yeah.
of what the total revenue from maybe state agencies, etc., should be. And based on that, he's able to make budgetary, plans, if you like, and spending on critical areas of the economy.
Salom, I
Yeah.
agree with you. But I'm saying that even if you look at the budget, ministries make specific proposals. So then if, for instance, the Ministry of Transport has come with a particular proposal on road tolls,
Or sky trains.
on road tolls, when you amend the Fees and Charges Act for tolls, make the Minister of Roads, because he will invariably
Yeah.
bring that proposal, because the Finance Ministry is a coordinating ministry.
Yeah, but
It's a
yes.
coordinating ministry for the purposes of revenue and for the purposes of following spending and seeing that we are spending within thresholds. So similarly, if the budget making process is a coordinating process, Salom, then we're saying that let's decentralize this, because then we wouldn't have had this discussion, because you're having two separate acts.
Yeah, so the proposals are made anyway. That is how come those ministries will have to meet the finance ministry. So they bring a proposal.
Right.
Finance ministry will say, okay, I think this is too high. I think this is too low, based on what we want to do, and based on other taxes and levies we are slapping on the people. Increasing this fee by this margin is too much,
Right.
or increasing it by this is too small.
Yes.
So because the finance ministry, manages the finance generally of the state and of the nation,
Yeah.
he's able to tell what is coming from where, and based on his own plans of taxes and levies, etc.,
Yeah.
he's able to harmonize everything. I think that's the reason why it has to come through him. But in any case, it is a proposal from the sector ministry.
Exactly.
And it is their proposal that is evaluated, that is looked at, considered by the finance minister or ministry, based upon maybe agreements, engagements with other stakeholders. Then we have a specific fee being increased or reduced, even though fees are normally not reduced. A particular fee being reviewed. So I think the last time these fees were reviewed were about 3-4 years ago, and many people have said that we need to also, do the Fees and Charges Act also in a way that will allow for automatic review, because it's a lot of money and a lot of time wasted getting all these ministries to come around to come and suggest what they want to do.
Yeah.
But if you can say that, let's peg it against inflation plus minus this after every 3 years, then we know that after every 3 years, maybe if I'm going to pay a toll, this is how much I can be looking at. But before it was increased the last time, it wasn't increased for many, many, many years. And so when it came, though it was not much, the margin was huge and people complained. But if it is somewhat automatic. I mean,
that
be able to predict what
automatic nature of fixing fees and charges you're asking for is easily operationalized if the sector ministry responsible for the fee or the charge is the one determining the automatic adjustments. Because at the end of the day, yes, the finance ministry will still harmonize. It won't be the road minister sitting at his ministry determining that I am reducing. It will have to be in consultation. I'm just saying that sometimes we pass legislation and then we give authority to different people. Then when it comes to implementing it, you see that there are challenges. Because if the one who designates the area as a toll area is not the one who decides the fees and how the fees should be collected and when to issue or ask that the legislative instrument be passed to seize the collection of tolls, then it becomes difficult. So I think that we need to maybe discuss this further and see how we can, one, include the automatic and also ensure that sector ministries become responsible for the fees and charges directly related to their ministries. So I don't see this. I don't see this matter ending. This is not the. This shows a certain interaction between Parliament and the executive.
Yeah.
And
I think what's really so good point. What's also happening is a certain assertiveness coming from Parliament. From Parliament. Because and I think this assertiveness as a result of the fact that we have a speaker who is not from the executive party. You know, so he thinks that maybe he could do same if he were from the executive. Maybe it's the personality of the person who thinks that he's been in Parliament for a long time. He's seen various administrations. He's seen various speakers. He can put the experiences together, the good, the bad, and see what he can come up with. Most importantly, the speaker in particular keeps talking about the independence of Parliament and the fact that the three arms of government are coordinated. They have the same powers, if you like. And so one is not necessarily more important than others. People may disagree, but that is the law, and that's how it appears. So he wants to assert the authority of Parliament. That's why recently he even said that he was telling MPs or reminding them of how powerful they are, to the extent that he told them that they cannot, in fact, the president cannot remove them, but they collectively can remove the president. And even went ahead to say the president cannot remove him, but he can. Or he can, through the processes remove the speaker. It's true. It may be theoretical if you're stretching it, but it's the fact of it. The president cannot remove the speaker. But when the right processes are triggered, the speaker plays a key role. Members of Parliament are crucial because in the end it will come down to a vote. And if all the members of Parliament, or majority of them, as the Constitution stipulates, are on the same side as to the reason for the proposed removal of the president. There are three things, I think: breach of the oath, breach of a law, or whether he is fit, mentally or physically. When they consider all those and they feel that the person can no longer hold the office of the president, they have a duty to vote to remove the president. But the president cannot remove the MP or the speaker like he can do for MMDCs, etc. So I think generally it's a certain level of assertiveness that we are seeing from this Parliament. Whether that assertiveness is gaining root and generating or eliciting the right effect, maybe we will see over time. But so recently we also heard about the situation where the speaker, for example, says the allocation to Parliament was very small, etc., and that allocation must be increased. My question was, what would the money be used for? Somebody answered and said, no, members of Parliament have needs. They have to go to their constituencies. They have to perform their roles. Parliament must have a way of funding all those things if we were to take the representation of the people seriously, etc. So I think in this whole road minister toll, suspension or cessation matter, what the speaker is trying to do is to assert a certain authority that Parliament has had but perhaps was not
Did not display,
exercising because of obvious reasons.
Yeah.
So, for example, like Clement rightly said, the minister ought to have gone to Parliament because the act was passed in Parliament.
Yes.
There are processes. So maybe to Parliament and generally, the gentleman did not follow the right processes. And Parliament is aggrieved. Parliament finds that as an affront to its authority.
Yeah.
And so Parliament is trying to assert its authority. So I don't know to what extent the Parliament can assert its authority, especially as we've seen in a very divisive, Parliament. But the point will be made anyway. So next time, if you want to do a thing like that, you think about it properly. That have I gone through the right processes? If no, you want to take steps to do that. But the more crucial,
I on this independence of Parliament, I think that it's
we're overstating it.
No. There's a certain history that, and I like history. There's a certain history that makes Parliament asserting its independence somehow challenging. When we had the legislative councils, they were mere advisory councils to the then governors of the Gold Coast. Okay. Those are the first footprints of Parliament. So they were just to assist and advise the governor. The governor was the president of the Legislative Council. Increasingly, you will see that per constitutional arrangement, we would have moved from a Westminster system where the head of the executive, the Prime Minister, is part of Parliament.
Where the Parliament is supreme.
Where Parliament is supreme.
Okay.
To a point where the executive will not be part of Parliament and Parliament is composed independently. Then now we have a system where it's fused. Now this hybrid system also has its own challenges. And the reason for coming to this hybrid system is also based on our history. Things that happened also in relation to budgets.
And the 1979 budget also.
In relation to budgets, that will cause us to adopt a hybrid position so that the executive has ministers who are in Parliament, so that when my budget is brought to Parliament, at least my ministers are there to speak to the government policy statement, to support it. So this hybrid also detracts a bit from the independence.
Okay.
So that when you are in Parliament and you're a minister of state and an issue comes up between the executive and Parliament, on whose side are you? Are you going to speak for parliamentary independence, or you are going to speak for executive power?
Okay.
So indeed, but so great, and it's been an issue that the judiciary has considered many times. So that's how come the judiciary has come out to say that the three arms of government, though independent, are not in a watertight compartment, which means that there's expected to be some interaction between them. So that's why in our current hybrid system, you have ministers who can be MPs. Indeed, the Constitution, enjoins the president to appoint majority of his ministers from Parliament.
We're going to be talking about the issue of appointment and the discussion of the MMDCEs in the next segment. Don't go anywhere. We'll be right back. Welcome back. Lots of interesting conversations about the three arms of government, and especially the executive and the legislature, and who holds sway, where, when, and all of those things. Well, we're going to continue the conversation, but we're going to also spice it up a little bit. The issue of MMDCEs, those who are the president's men in various parts of the country. Should we vote for them, or should the president just appoint them at will? Well, what does the law say? And there's been a lot of agitations recently for people to be part of the process of electing who it is that represents them with the executive. Let's find out what the law says. Right, gentlemen. Yes, Selo.
Yes. So just before I get there, just a quick point on the previous topic. So my major concern with all these road ministers' directive to suspend or to seize the collection of the tolls is with the revenue, what impact it has on the revenue projected from the beginning of the year.
Okay.
So we are saying that we don't have money, but few months or a month or two to the end of the year, we have stopped collecting the road tolls. I don't know how much specifically they collect on monthly basis, but do we have provision or do we have a way to fill the gap that this cessation will cause, so it may not be detrimental to the general, fiscal aspirations of the country? That's just my view.
But I can give you an answer for that.
Okay.
Yeah. I mean, just yesterday, I heard the details on, the fact that we have 4 billion potentially that can come from all forms of e-transactions, as revenue, vis-a-vis 70 million that's coming from.
But you see, that is just a proposal.
I will not even go.
That is just a proposal. It is possible that Parliament will shoot down the e-levy and everything. So if Parliament shoots that down, the 4 billion or 5 billion projection we are told we'll be getting from the e-levy, etc., will not be there. So what then happens to that gap that would have been created from the cessation or suspension of the toll of the toll? That's just my point. And did the finance minister
why would Parliament shoot down?
If the cessation was done using the right procedure, would you raise this question?
No, because that
exactly.
Wait,
so that's the point. That's what I'm saying. That for us, we shouldn't even be quibbling over the quantum of has the procedure been followed? Because if the procedure was followed, we will not even care whether there's been a shortage or that. Then it means that once you follow the procedure, Parliament is in. There will be a legislative instrument, at least. That legislative instrument will explain to Parliament, even though Parliament cannot touch, amend, or make changes to a legislative instrument. Parliament has information that you're going to do this, and they're giving enough comfort that when you take this action, it will not affect our revenue.
Exactly the point. So it is that lack of information. So if we knew that, so perhaps this will be seized or suspended. Perhaps the LI will make provisions or explain to us why it is so.
Okay.
That will offer us some comfort.
Okay.
But to just be communicated to by way of a press release or a letter, I think it flies in the face of the law. That's why Parliament feels very much disrespected, for the want of a better word.
Okay.
So back to you. Want to say something?
Yeah, no. I mean, I'm fine with this because I say that once you have the power to do something, and you use the right procedure, nobody will
come at you.
Because now did he have the power? How would they affect the national economy? Wouldn't be having this discussion in relation to that. And I think that as Parliament also showing that yes, we want to assert our authority when it comes to the power given to us. We will need to pass the appropriation bill. Parliament, yes, it's right. But we also have a certain history where budget proposals sent are the ones that are passed. So there's a certain, yes, the budget is read 99% of the time. It will come out as read.
Everything.
So that also might give the executive what we will call a certain course of dealing. And they can rely on that course of dealing and say, once we've come to you with the intention then that we want to, with a proposal, not even an intention, with a proposal, so we know that you will allow us because we are managing and we know how to ensure that you, Parliament, you get your deal, executive will get, and the judiciary.
All right, let's jump into MMDC.
So given the whole discussion, what the Speaker has said, the response in the letter form from the Ministry of Roads and Highways, how do we resolve this issue? Do we just leave it that way?
No, I think that
the court will have to come in and resolve it.
I think that the calling of the minister by Parliament, just for the minister to explain to Parliament, for Parliament to say that this should not be done again, is enough. Now, a private citizen can decide that he will want to go to court to test this power. I'm saying that going to court, the law is clear. Yes, he has the power. He must follow a certain procedure. In this situation, he didn't follow
the procedure. So
we have stopped collecting the tolls, and the executive has provided the police to man the toll booths. So you will see that it's not Parliament must just call the minister in, like they've done in other situations where ministers have acted without recourse to Parliament. We all remember the Sputnik issue. Yes, you go to Parliament, explain yourself, Parliament to say this should not be done. And for all of us, it's important that we follow the procedure when we have the power. And if you don't follow it, then the procedure will not protect you when you have exercised that power. So that's the point. That's my closing on this.
That's fine.
So are we electing or are we not electing?
So I think it's a matter that divided opinion sharply when it came up in 2019 or so. That is in respect of the election of MMDCs. And I think it's come up again in recent times because of the issues we've had with the confirmation of MMDCs across the country, where we've had, situations where some people were perhaps attacked. There were military and police or security presence at some of the places. We had reports that the venues were changed last minute. People were taking somewhere to go and vote. Others did not know. Obviously, those who did not know were people who were going to vote against the candidates, etc. And so to prevent all these things, the discussion is being revived. Why don't you vote for the people so that we stop all these? And indeed, the president in one of his addresses, expressed his willingness to broach the matter again and regretted the political acrimony that dogged that process. And he says that he hopes to be able to garner a lot more public support for it. But the public support for it, it could be either this or that, in a sense that the president's view is that the election of MMDC should be done along partisan lines or along party lines. The other side thinks that no, we don't want it to be done along party lines with stated reasons. And so yes, election, we are all for it. That is one thing both sides agree on. However, the mode or the process or the how, which is always a problem, is the problem in this case as well. One says make it, along party lines. The other says, no, don't do it that way. Let's do it the way it is. The other one says, no, you'll be behaving like hypocrites, like ostriches. The thing is politicians are already influencing the process. Why don't we just open it up so that it is political and we all know, or partisan, so we all know. The other side says, no, if the law says don't make it partisan and you are making it partisan underground, that is in breach of the law. Let's call those people out and let's deal with them as the law says. But so it brings up the matter again. But what are the legal matters in this? The Constitution is quite clear about, what decentralization should mean for the country. Indeed, there's a whole chapter on of the Constitution, chapter 20, that deals with decentralization and local government.
Oh, wow.
All right. So 240, Article 240 says, Ghana shall have a system of local government and administration, which shall, as far as practicable, be decentralized. As far as practicable, be decentralized. Decentralization is important because central government cannot sit in Accra and purport to do everything, including market tools, lorry park management, etc. Government cannot sit in Accra and purport to be doing that, or even at the regional level. That is why it's important to have the district assemblies in place, which has people from the local areas, taking some charge of their government. And government has a representative there who is the DC or MCE or mayor or however we may call him, so that the administration of those local units, will be seamless and it will be proper. Now, to the bigger issue, should the election, yes, we must do it. We are all for it. We don't like all these things about people, allegedly bribing assembly members, etc., to vote for them to become to serve them. You bribe me to vote for you to serve. It doesn't make sense. There should really be something in there that should cause you to be bribing me. 241 says that. So talks about how the country should be divided in districts. 242, 243. 243, it's important. There shall be district chief executive for every district who shall be appointed by the president with prior approval of not less than 2/3 majority of members of the assembly present and voting at the meeting. So this will have to be looked at if you want to vote. So the element of appointment by the president will have to be amended or taken out of the Constitution. So that is one. When you look at 248, which is also another important one, a candidate seeking election to a district assembly or any local government level shall present himself to the electorate as an individual and shall not use any symbol associated with any political party. So this is prescribing political party interference or intervention, however you look at it. It goes ahead to say that a political party shall not endorse, sponsor, offer a platform to, or in any way campaign for or against a candidate seeking election to a district assembly or any lower government unit. This is also clear. So if you are to just go by this is not an entrenched position. Okay. So if you have to go by this, we don't need a referendum to get that amendment done. Right. Parliament, by the right number of majority, can actually do that, like we did in 1996 when we amended part of the Constitution. Okay. The Constitution has actually been amended before, but the portions which were amended were not entrenched. So we did not see a lot about it. But indeed, the Constitution has been amended. So if we want to do a non-partisan election of MMDCs, as we do for the assemblymen, etc., we don't need a referendum. Okay. All we need is the right parliamentary processes triggered. Yeah. We have the right number of persons voting, I think 2/3 or so, voting to ensure that this is done. And so this will be amended. And so this will be amended plus the part that talks about the president appointing the MMDC so that they are together. Yeah.
If you want them to...
The difficulty, however, is with introducing the partisan element into this whole discussion. And with that, we go to Article 55. Okay. Article 55 is an entrenched constitutional provision. So 55 so it talks about the right to form political parties being guaranteed, the fact that every citizen of Ghana of voting age has a right to join any political party, and also talks about the fact that a political party is free to participate in shaping the political will of the people, to disseminate information on political ideas, social, economic programs, and of a national character, and sponsor candidates for elections to any public office. I see. But other than to district assemblies or lower local government units. Wow. So because of the second part of this particular provision I've just read, which is an entrenched position or provision, if you want to amend the Constitution to allow for partisan participation in local government elections, you have to deal with this. Okay. And the law or the rule for dealing with such entrenched constitutional provisions is to conduct a referendum, which is a whole election across the country. Yes. And then you put the question. And so if, I don't know how the question will be framed. If the question is framed in such a way that maybe, let's say, if you want elections, MMDC elections to be partisan, yes. If it shouldn't be, no. And yes wins, then it means that we have agreed as a people to change this. And so we will change this, then now we will vote based on partisan lines. But the merits and there are merits and demerits of this argument. The people who think that it should not be made partisan are of the view that we are tied with political parties. Yeah. NDC, MPP, everything, NDC, MPP. When you're even going to buy food, NDC, MPP, you are going to buy water, NDC, MPP. Why do we want to, why do we want to deepen that division?
When you are stepping
to the local
level, you
have
to check whether the cap you are wearing is which color.
There are times you want to pick a tie.
You have to consider where you are going.
You have to consider, because there are some colors. Yeah. So now you can't freely wear a tie which is red and blue and white. No, you can't. It may be a nice color, a nice combination. Yeah. You cannot just do that.
I can't.
No, and go to certain places.
You'll be wasting you.
Or you can't just wear colors green, blue, red, black. You can't just do that. Because if you do that, you'll be looked at in a certain way. Yeah. So people are saying that we are already tired of this. Why will you want to deepen this by extending the frontiers of this political invasion into an otherwise a place where you can say that cool heads prevail at meetings and decisions are taken? The decision-making process may be slow, but decisions are taken anyway. There may be one or two very active persons in there who are motivated by political party interests. But we all know that as part of the rules, we are not supposed to be doing partisan things. The other side also argues that the interest in these elections are very low. The individuals do not have what it takes to mobilize the numbers. The political parties have the machinery on the ground already to call the numbers to vote. And it is the political party agenda they will implement at the various levels. I mean, the arguments here and there. But, is that what, do we really want to do? The partisan one or this one? I think it's an issue that we will have to look at again. And
so
the discussion
I think
the
referendum is obviously where we need to go.
No,
the referendum, the other point is it's expensive.
Yes.
Will you want to put in money in that? Will you want to put money in that when you say you don't have money?
So if you want to go partisan referendum, it means you're going to amend the Constitution. If you say we should just elect, then we can go. Salom has laid a very good foundation. But I think that even goes beyond whether we should do it on political lines or not. If you look at Article 240 of our Constitution, it says, Ghana shall have a system of local government and administration, which shall, as far as practicable, be decentralized.
Okay.
Now, and this is one of the provisions that the Constitution Review Commission will tackle and tell us that we need to define the system of decentralization that we want. Because there are different forms.
Yeah. Okay.
There's devolution, there's deconcentration, there's delegation.
Okay.
Now, our Constitution does not clearly tell us.
But
de jure, if you look at
what's de jure? We are learning now.
De jure. So by the law.
By the law, de jure. Okay, all right. Let's
so
go.
If you look at
de facto
yes.
and de jure.
De jure.
Okay. So by the law, if you look at what we are practicing, we are actually doing devolution.
Okay.
But we've not perfected devolution, because then it will mean that at the district level, the DCEs will have certain powers devolved to them. They will take certain, so both devolution of political power, physical power, so to manage, and also to some extent legislative power.
Okay.
So de jure, what we are doing might look like, but our Constitution does not define. And it is this lack of definition of clarity on which system of decentralization we want for ourselves as a country that is fueling this divide of political or non-political. Because if we have the system clear in mind, that is a system where at the local level, persons apolitical are giving the room to engage in governance, then we will approach it differently. If the system of decentralization we want is that which is just deconcentration, moving things from the center, so a replica of Jubilee House
here in other places,
in my district, then we will decide that we are going. So the lack of clarity around the system is what is bringing this divide.
I wanted to ask a couple of questions as we wrap this segment up. Is that the delay in appointing the status quo, what we have now, the delay in appointing the MMDC is what happens in that space? It's like are they still functional? Because your tenure has passed. You're in a new dispensation. A new government has been sworn in. The president has been sworn in, but you haven't been sworn in. What happens in that space? There's a law, coverage of that.
Yes. So there's a whole machinery at the district level. A lot of them are not civil servants, but local government service people. Who are generally in they are workers. They used to be civil servants, but now they are local government service people, So that structure is a technical structure headed by the district coordinating director. The MMDCE is just the political head who gives political direction, etc. The technical job is done by a certain structure already in place. So when a DC is not in place, the place is not stagnant. A lot of work can still be done, even though some will require the specific involvement of the DC, etc. So the district coordinating assembly or district coordinating director is there, the team is there, the various institutions of state are there, SRAJ, GRA, they are all there who will be working because their work must continue. When the appointment is not done, of course, it may slow down things a bit, but there's always a way of getting somebody to sit in.
Things to do.
So if you realize that the appointments were done recently, But for all the period the appointment was not done, or we're waiting for the appointment, they were still acting.
Okay.
They were still acting in a certain capacity,
okay.
even though they were told expressly not to engage in certain activities.
Okay.
They did not have to commit the government to many things,
okay.
but they were still there to ensure that government programs and plans were running.
Okay. All right.
And I recall in 2009 when Professor Mills took office, what he did was he gave the directive that all DCs should remain at post, even though they were from a different regime, and also gave the same directive that they should ensure that this does happen, etc. Okay. Just to ensure that the place keeps running. Yeah.
Okay. All right. Thank you. We're going to take a short break. Up next is the docket. Don't go anywhere. Welcome back. It's time for us to get into the docket. Now, of course, this is a segment of the show where we are basically dealing with your issues, whatever challenges you have. You write into us, we take out the issues, and we try to give you answers here. Today on the docket, we have, I have been married to my husband, a Ghanaian who is based in the U.S. for 8 years now. I got pregnant for him before marriage. He went back to the U.S. right after our wedding. He only came to spend less than 2 weeks in Ghana when our son was 5 years old, and that was all. I have not set eyes on him again. We have little or no contact. He neither picks my calls nor does he call me back. He's always in a hurry to leave whenever we do get a chance to talk. These actions have put a strain on our relationship. But I have stuck around because of our son. Recently, I started hanging out with an old friend of mine, and we have grown incredibly fond of each other. There's been talks of taking the relationship to the next level, but I do not want to encourage it because I am still married. I have tried every means possible to get my husband to discuss the state of our marriage and the way forward, but he is unwilling. I want to move on with my life and start a new family. How can I do this legally without any repercussions? Is it possible to divorce someone in their absence? How can the law help me?
So interesting.
Yep.
Very.
I heard the first line that they've been married.
Yes.
Now, how you break a marriage will very much depend on the type of marriage you're in. So in Ghana, the Marriages Act will recognize 3 types of marriages: customary, Mohammedan, and ordinance.
Okay.
Now, there are instances where your customary marriage is converted to ordinance.
Okay.
Now, that's where erroneously you say, I had an engagement and then I had a church wedding. There's nothing like engagement and church wedding in our laws. You have a customary marriage that you convert. Now, your customary marriage is potentially polygamous.
Okay.
What it means is that the husband and I will say the wife can also decide that we can bring others. So it's potentially polygamous.
Okay.
So when you convert your customary marriage to ordinance, then it becomes monogamous. So if you are in a monogamous marriage, you cannot bring in another person.
Okay.
So to answer this person, we will need to know
a little more
the type of marriage, and that's very important because then that will lead to the next step. Because if it's an ordinance, to break an ordinance, you need a petition.
Yeah.
There's a process for the petition. The other party, who is called the respondent, so the one who is filing for the divorce is the petitioner. And then the one against whom will be your respondent must be served with the petition. The person must respond. If it's a customary marriage, because it is custom and is marriage at custom, custom will have a way to break it.
Okay.
Sometimes it's just a return of the customary drink or the head drink that was taken for the purposes of the marriage.
Yeah.
So that one, you don't even need the
presence of the person.
You just return,
Yeah.
and then you perform certain customary rites that the custom will determine as you divorcing. Muhammadan also, they have there's the talak.
Talak, 3 times or something.
3 times touching you, talak, talak, talak.
Yeah, done.
A divorce is done.
Wow.
And in that marriage also, there's room to get
more spouses.
More
men.
Spouses.
Sorry, women.
More wives.
So,
So more wives.
Yeah.
You say spouses.
No,
right?
more women,
Yeah,
more wives.
More wives. So the type of marriage is very important in this discourse. But definitely, if from the narration, she knows where this man lives in the U.S., so there can be attempts to, if it's marriage under the ordinance, to try and serve him. She needs to see lawyers for other advice. But generally, the type of your marriage determines how you dissolve it.
Okay.
All right, so good foundation. So we don't know what type of marriage it is.
Yeah.
Customary,
Wrap it up for us. Yeah.
Mohammedan ordinance. Like Clement said, the dissolution of the marriage will depend on the type of marriage it is. But we are assuming that it's ordinance because sometimes ordinance is the most difficult one to break. So I think she raises a number of issues that they've not been together for a very long time.
Yes.
Under our laws, I mean the Matrimonial Causes Act, for example, there's only one condition under which you can divorce, which is that the marriage is broken down beyond reconciliation, or the marriage is irretrievably broken down. In other jurisdictions, they will say, but we say that the marriage is broken down beyond reconciliation. There are a number of things you have to state to prove that indeed the marriage is broken down beyond reconciliation. Okay. So, out of one is adultery. If you can't stay with a person because you think the person is committed adultery, it can trigger the process. Okay. You've been desertion for about 2 years or so, for about 5 years. You've not lived as spouses, unreasonable behavior, which is very nebulous and very wide, and about two more conditions. I may, from what she has stated or narrated, it appears she may come under desertion or not lived together as husband and wife for about 5 years. Yeah. So, and she can go under the desertion bit of the conditions and start a process. Yeah. Whether the person must be there or not, I don't think so. What is important is that the person must be served. Okay. So the person doesn't live in Ghana. Like Clement rightly said, there are processes to serve somebody outside of the jurisdiction. Yeah. There's a procedure to use. Once that, fortunately, she knows the address of the person outside. Yeah. Once that procedure is used to serve the person outside, the processes can continue. That is done in order to give the other person, a hearing, to give the person an opportunity to also respond. Yeah. But the court cannot wait for the person in perpetuity. There are times and things attached to everything. Okay. So if all that is done and we are still not hearing from the person, it will not be fair to also hold a hostage that because the person has not responded, you can't move on with your life. So it depends on what she puts together. But yes, it's very possible to go ahead with it. I think her lawyer will advise her on exactly what to do.
But she cannot enter into another marriage.
No, she cannot enter into another marriage until this one is totally dissolved. Yes. Right. Else that will be a crime called bigamy. And she may go to jail for that.
All right. There is a high price to pay for bigamy, so you don't want to get involved in that. Well, we're going to come back as we take a look at our legal trivia.
Legal trivia. Do you know that any person who cruelly beats, kicks, ill-treats, overloads, tortures, infuriates, or terrifies any animal, or causes or procures, or being the owner, permits any animal to be so used is guilty of the offense of cruelty and is liable to a fine. This can be found in Section 303(1)(a) of the Criminal Code, Act 29. Take note and do the needful. That will be all for our legal trivia today.
I want to say a big thank you to my guests, Selim Adono and Clement Kojo Akapam, for being such wonderful guests on this show. Thank you too for watching. This has been A Question of Law. My name is David Kwekusechi.